joining us today, this Thursday, June 21st. We're excited to have everybody with us. We've got a great presentation for you today, and I'm really excited to have our speaker back with us again. But as we like to do, we like to start off by first recognizing all of our community partners. This is just a sample of our community partners. We could not do these boot camp sessions without them, their time, their effort, and their expertise. For those that are new to the Small Business Boot Camp, it is designed to help small businesses prepare, plan, and grow. It is a statewide initiative supported by all of our community partners. And not only is it our every Tuesday, 9 a.m. webinar, but it also consists of a content library and a series of workshops with some of our community partners. So the content library. Since the beginning of the boot camp session in April of 2020, we recorded all of our webinars, and we make those available to all of our participants because we know that sometimes you can't make it at 9 a.m. And you want to watch the content. And so over the last 2 years, we've been able to compile all these recordings into our content library, and we have a collection of over 200 webinars available to you at no cost. And you can sort through the various different filters. You see that there's 7 different categories you can sort by and find the different sessions that may fit the needs you're looking for. And then if you have questions also, you can't find a certain topic, you can always feel free to reach out to us and we can guide you to where it's located in the content library. But it's a great resource. You can share the links with others through email, and it can be viewed anywhere at any time, as long as you have internet access. So it's a great resource, a great tool available to you. The ACA also has another number of other programs that are available to small businesses. We have our small business services, our workforce division, and our Arizona MEP, our manufacturing extension partnership. Additionally, we have a program called the Small Business Checklist, and this is designed to help entrepreneurs and business owners identify the commonly requested licensing, registration, and compliance needs at the local, state, and federal level. It's an online interactive guide, and you just check the boxes and you get results. Or if you're looking for a quick answer with some basic information, you can try our virtual assistant, Sally. You can see her picture there in the bottom of the screen. Sally stands for State and Local Licensing Information. It's a nice little chat bot, so feel free to test out Sally, our virtual assistant. Real quick, I want to touch on a couple small business updates. There are lots of opportunities for additional education. We're going to post a link for the SCORE website or their calendar. They've got some great webinars coming up as well, and SCORE is a partner of ours. They've been on the boot camp multiple times. Our presenter today has also done workshops with SCORE, and so we're going to list some of their calendar information in the chat. You can link to it and see what other workshops they have available. And then I also want to mention for those in Santa Cruz County, Santa Cruz County has a forgivable loan program, so we're going to post a link for that in the chat. One of the things we like to do on the update section is when we see new information on programs from counties or cities, we like to share them here as well. So as more programs come out, we will share those in this section. With that, we also want to remind everybody or let everybody know that the Small Business Digital Academy applications are open. The Small Business Digital Academy is a 6-week program that we run to help small businesses scale their online presence and build their digital capacity. There is no cost to participate except for your time. It does require about 4 hours a week of time commitment to maximize your learning from the course. It is a 6-week program, cohort style, so you'll be in it with a number of other businesses. We do a hybrid structure where there's some live learning and then some online sessions to go through as well on your own time. And then we also work with some mentors that participate to help support the businesses that are going through the program. So if you're interested, we're going to post the link in the chat. You can go to the page, read about the program, and if you're interested, you can go ahead and apply. Let's look at some upcoming sessions and the upcoming calendar. So next week on Tuesday, we have a strategy to achieving success. This is a new presenter. We're looking forward to his presentation. Then for the week of the 4th of July, we're taking the summer break for Independence Day. And then we will pick back up again on July 12th, Tuesday, July 12th, with cost cutting and managing cash flow from our expert friends at the Yavapai College Small Business Development Center. And then on Tuesday, July 19th, we're going to have habits for successful growth. And so we're looking for this one as well. So we got a lot of great lineup coming forward in July and all throughout the summer. So we look forward to seeing all of you every Tuesday morning at 9 a.m. for these sessions. With that, we're going to jump into today's session. We have Brian Burt from Snell Wilmer. He's the Emerging Business Group Chair and works with a lot of organizations around the valley and around the state to help provide information to emerging businesses, startups, and so forth. Brian's been with us multiple times on the boot camp, and we're excited to have him back. This is one of the best presentations we have, so I'm glad you're here to join us today. So with that, I'm going to turn the time over to Brian. And as he's getting set up, I want to remind everybody, if you have questions, please place them in the Q&A at the bottom of your screen, and we will use the chat for other communications back and forth. So with that, I'm going to stop sharing, and Brian, it is all yours.
All right, thanks, Robert. Great to be here again. Let me share my screen and we will jump right into it. All right, can you see that?
Yep, that's good.
All right. Well, thanks for attending, everyone. I hope you enjoy today's program. We're going to talk about in the next 55 minutes or so how to avoid the top 10 legal mistakes that can destroy your business. We're going to cover a lot of ground in those minutes. So feel free to, as Robert said, take a look at the presentation after, or happy to give you a copy of the slide deck as well for reference. Jump right into it here. Just a note that I get to work with entrepreneurs just like yourselves every day on the business side, so helping folks handle all the issues we're going to talk about today. I'll throw out in advance that I'm always happy to do a free initial consultation with anybody. So if you see any issues on the screen that you might want to chat offline about, feel free to email me, and happy to schedule an opportunity to do that. I also often do a free legal audit, which involves kind of taking a more comprehensive look at what kind of where you're at to date in your company, whether you're just getting started or you've been around for 10 or 15 years, and kind of help you think through best practices and things you might not be doing quite right, or issues you know you have and need to fix. Kind of walk away with a checklist of items to tackle at your convenience. So again, that's something I'll throw out for consideration as well. So feel free to follow up with either of those items. With that, let me jump right into our first issue of the day, selecting the wrong form of corporate entity. So these are the options that you have for those who are already in business. You've picked one of these. You've got a corporation. It comes in the standard C Corp variation, or if you elect S Corp status, that's a tax election to be a pass-through entity. A lot of you may be a limited liability company. Probably very few, if any, are in the limited partnership these days. So those are the options. And I'm going to talk a lot today about what I call myths on the street, things that people think are true but aren't true. And there's a lot of misinformation on the internet, a lot of misinformation that gets shared between friends and colleagues that, again, they think are the case, but not quite so. First one of the day, all entities do offer equal liability protection. You don't need to be in a C Corp to protect your personal assets from liability. If you set up any of the entities correctly, you can get that liability shield in place, which is the critical reason for doing so. I'm a big fan to start off with an LLC. I think they offer maximum flexibility to structure your company in a way that makes sense, and you only pay one level of tax. So it is, I think, an ideal starting place. Another one of these myths on the street, we hear lots of folks say, well, geez, I'm going to raise capital, so I've got to be a Delaware C Corp. That's just not the case. You're not going to go wrong if you do that, although you put yourself in that double tax entity from the beginning. There are plenty of investors. I deal with companies all the time in the capital raising process. We're going to talk about that in a few minutes on a different slide. And unless you have a goal of and a realistic chance of going public, there's no legal requirement that you be a C Corp. Now, there are some investors who will want you to be in that structure, but no legal requirement that you've got to do that unless you're going public at some point. For the 99.99% of the companies who will never go that route, an LLC may be a great starting point. You can always convert if situation requires. So if you get to that investor who says, look, you've just got to be in a C Corp, take my capital, and that's the one investor you want to partner with, you can always restructure the company to put yourself in a position to accept those dollars. But again, I think offering yourself kind of the maximum opportunities in terms of flexibility, corporate structuring, and only one layer of tax is a good way to start. Like with anything we're going to talk about today, if you've got an issue identified, it only gets worse with time, doesn't get better. So if you see anything in today's discussion that you say, hey, I might want to take a closer look at that, I encourage you to reach out and figure out how to maybe remedy the issue, because as things, and we'll talk about as time permits, kind of a horror story on each of these topics. I think it's always helpful to give you a real life example to kind of drive the point home. Our first one today is a classic example of things not aging well. We had a local company that was first generation C Corp and passed it to the second generation, didn't really think through options to maximize tax efficiency. Second generation inherited that company, grew it quite substantially to the point where it was worth 20 million, and decided to bring us in to help for a transition to the third generation. And when we got brought in, the transition to the third generation had to happen quickly. It wasn't something they had years to do. It was a fairly immediate need. And unfortunately, for the current second generation, there was no way to get them out of a double tax situation for that $20 million worth of value that they already built the company to. And so at that point, you can just do the math and figure out how many extra millions of dollars would need to be paid in taxes because of that double tax structure. The third generation, we restructured to get the benefit of an LLC subsidiary, so they would be okay. They're going to come into it and only pay one layer of tax as they grow the company further and hopefully lead themselves to some kind of liquidity event. But the second generation was trapped, no way to work themselves out of it. And again, millions of dollars in wasted profits that they could have put in their pockets. So think through what structure you're in, or maybe you're contemplating. A lot of people default to an S Corp, for example, which isn't necessarily a bad choice. It comes with a host of restrictions that may make it very difficult to raise capital or do some of the other things you may want to do in the company. I know it's a favorite option of CPAs sometimes, because there is a short-term withholding benefit that you wouldn't get necessarily in the LLC. But again, I always encourage folks to think of the broadest picture possible to kind of incorporate both pros and cons as you start and grow and hopefully exit that company at some point. Number two, not protecting your corporate shield. So if there's anyone out there operating in a sole proprietor, stop immediately and think about forming a company. It doesn't cost much to do it. It's a fairly quick process. And at the end of the day, you are going to get hit with, depending on how long you're in business, it's inevitable, with some claims. It may come from an employee that goes sideways. It may come from a customer that's not happy with your services. It may come from a vendor or supplier that you're dealing with. It's going to happen at some point. And you want to make sure, as I always say, the worst case is you bankrupt the company, wind it down and go home. And you've protected your retirement, your kids' college fund, your house, etc. And one of these additional myths on the street is that once you form the company, you're good to go. You've turned your articles of incorporation or organization into the Arizona Corporation Commission. You formed your company, and nothing can happen going forward. And that's unfortunately just not the case. You've got to take some additional steps to ensure your assets are protected. From a legal standpoint, we use the phrase piercing the corporate veil. That's legalese for doing something that would cause that corporate shield to be subject to attack by creditors who say, you know what, I'm not going to just go after the corporate assets, I'm going to go after your personal assets as well. The following things can contribute to that. Number one, and most importantly, entrepreneurs not big on corporate formalities. Another reason I like the LLC is there are very, very few corporate formalities that you got to comply with. In a corporation, there's all sorts of formalities, and the more there are, the more we see people just not paying attention to those. Not for any malicious reason. You just get busy doing more exciting stuff, and we get that. But those formalities go to the side, and we see that opportunity coming up for that creditor to pierce through to your individual assets. Things like not forming separate bank accounts. You operate your company and your personal life out of the same bank account. You don't have separate books and records. You don't have a clear structure with you interacting with your company. For example, you put more money in, as is often the case, to fund things as the company starts to grow, but you don't document that. Is that some paid-in capital? Is it buying more stock? Is it a loan? And so you really don't separate personal from company. Second, you undercapitalize it. You hope revenue is going to kick in, and you go out and generate a bunch of expenses for your startup. You might hire some employees, you might lease some office space, you might get some equipment. You hope revenue is going to kick in. It ultimately doesn't, and you feel bad, but you close down the company, and there's $50,000 worth of obligations outstanding. That's undercapitalization. If you haven't put enough capital in, whether through your dollars, loans, or other form, to make sure you can pay those initial bills when they come due, you may provide great opportunity for those creditors to pierce through that shield. And finally, fraud. And we're not assuming anyone's going to go out and commit some fraud here on the phone. What we're really talking about is, and this comes up quite a bit, you get laid off from your employer, or you decide to quit, and you've got a non-compete in place. And people raise the issue all the time. Well, I can't compete personally, but what if I create a company? That company never signed the non-compete with my former employer, so I'll go ahead and do what I couldn't do individually through the company. And unfortunately, you can't do that either. What you can't do individually, you typically can't have a corporate shield to try to get around the rules or the contract that you signed. And so that may be another opportunity. Personal liability, even if you generate the corporate shield and keep it in place by doing the things we've just talked about briefly, personal liability can still exist in other ways. Obviously, if you commit bad acts, you violate the law, etc., the corporation is not going to shield you. The big one is the personal guarantee, and probably the most tragic story we talk about today. This was back right before the last kind of Great Recession of 2008. We were vetting term sheets and opportunities for a local company, been around for a while, really nice owner to sell the company in a $60 million sale. Would have been a great payday for him and his family. And as is often the case, there are personal guarantees on the business, millions of dollars in personal guarantees from banks. Oftentimes when you go to pay those back, there's a whole process that you've got to go through. And so people say, hey, let's just wait till we close the deal, bring the capital in from the buyer, and just do it all at once. Let's not create a separate process. And so that's what happened here. And had the money to pay these guarantees back at any point along the way, because the company had done very well, decided not to do that. Well, we all know what happened in October of 2008. The industry he was in got hit particularly hard here in Phoenix, went from 60 million to zero almost overnight. And that, again, that should have been the worst case. That's pretty bad. But unfortunately, the banks didn't have a whole lot of sympathy, saying, hey, we see you just lost your company. We still need to get repaid. And so they called those personal guarantees. So it would have been a already tragic situation turned even worse when those bank guarantees came calling, and something that could have been avoided if he had, along the way gotten rid of those, but that didn't happen. So encourage you, if you've got to get them, and they do exist for leases, SBA loans, etc. You can't always avoid them, but you can monitor and get rid of those as quickly as possible. Number 3, putting all corporate eggs in one basket. So just like the reason you formed a company to protect your personal assets, you can do the same thing within your company structure. You can create multiple entities to shield things within your company and its operations from liability. You can create a variety of different structures. Some people do a holding company and some subsidiaries. Some people do affiliate structures where you own 2 or 3 companies directly. It really depends on your particular facts and circumstances, but the goal is to fence off different things. One, for example, different lines of business that maybe have different risk profiles. One business a lot riskier than the other, so you put that in a separate entity so that if that risk materializes, it doesn't take down the entire business operation. That less risky business operated in a separate entity lives to fight another day. You may go into different geographic areas, whether different countries, different places, again, that have different rules and regulations, and want to make sure that those new places you're going don't impact the current operation. Another reason people do it is to put assets, valuable assets, which could be what you see on the screen, real property, could be intellectual property, into a separate entity. And for example, you buy the property your business is operated out of. Sometimes that property is worth as much or more sometimes in the operating company. Put that in a separate LLC, lease it to your operating company. Something happens in the operating company, that real property is safely tucked away in a separate entity and doesn't become subject to those customer claims, for example. Same thing on the intellectual property. You can put your patents, trademarks, your brand in a separate company, license it to your operating company. And again, if something happens, that IP is safe and available for future use. There are issues to doing it, so you've got to pay attention to those. The sooner you do it in the life cycle of the company, or even at the beginning, is best. The better, because it can minimize what you need to do to get that in place. As long as there's nothing happening in terms of active claims, you can do it anytime. Again, as the company grows, there's more kind of meat on that bone to go through, but it's an opportunity that presents itself at any point along the life cycle and may make a whole lot of sense to think through, particularly in these uncertain times before the recession may hit us in the not too distant future. The lesson learned here, we had a company that was developing software within an existing operating company. They were going to move that software to their own company, or separate company, I should say, to commercialize it. Didn't really think about doing it before it was ready. Unfortunately, got hit with a class action lawsuit in the existing company. Now that software they had paid $200,000 to develop was subject to that claim. And so long story short on this one, they had to essentially structure a buyout of the software they already paid for to buy it out and put it in a new co. And the reason being that now that software was subject to that claim. If they won the lawsuit, that software would be part of what they got. So they couldn't just take it out without replacing it with the value of what it was worth. In that case, the development costs were the minimum value of that 200. So this one ended well. They settled the lawsuit and they ended up just paying themselves essentially a couple of payments. But you could see how that could quickly have turned into a situation where they doubled the cost of their own software by having that claim hit that company. So just one example of how you can avoid those issues, taking down the whole structure and preserving assets and mitigating risk. Number 4, why do you need a shareholders operating agreement? Well, if you've got partners, any partners, including family members, you will disagree. And the purposes of these agreements are to do everything you see on the screen. Anyone who says, hey, I'm in business with family, we'll figure it out. I can tell you from many years of doing this that the family disputes are the nastiest. We've had an identical twin brother sue a brother. Recently had a client where an aunt was threatening to sue her niece. It happens constantly. You've got the business issues and then the family dynamics on top of it. Even if you're not in business with family, you're going to disagree. It's inevitable. And unfortunately, the corporate statute, whether it's in Arizona or any other state you form in, does not give you a default playbook to address the issues you see. It's not going to automatically align expectations. It's not going to allocate management, economic, and other rights. It's not going to provide an orderly way to get out of the company if you decide to leave or if you need to expel a certain member for doing bad stuff. And it doesn't help you resolve disputes. Disputes that often can't be resolved by a court because they involve business disputes. No one's stealing anything. You just decide you want to go in a different direction. So the statute maybe addresses at best 20% of the things that may arise and may not do so in the way that you think makes sense just with that 20%. The other 80% is left open. And so if you don't enter into an operating or shareholders agreement, you have no playbook to turn to when things go sideways or there's disagreements or other issues you need to confront. So highly encourage you to do that. It is some of the best money you will ever spend. And there's a whole host of horror stories that you could go through in today, this particular issue. For time's sake, I'm just going to do a quick one, and that is people assume, again, the statute provides for obvious provisions when things go the way they shouldn't. And you would assume in a situation where people commit multiple felonies, steal millions of dollars from the company, that the statute would provide for a quick, easy, and cost-effective way to get those owners out of the company. Unfortunately, that's not the case. We saw that happen. Those people got terminated. The owners, who were also serving as key executives in the company, they proceeded to sue the company, and 7 figures and a year plus later, 7 figures in legal fees, that is, not to mention the other costs, and a year plus to resolve that issue. The same company, after realizing they probably needed a good operating agreement in place, had a similar issue, not as bad, but a similar member gone sideways, was able to resolve the issue in 1 day with no legal fees, when it happened, unfortunately, to this company a second time. So again, we could spend the next half hour going through dozens of other examples. See a lot of these things, typically working on 2 or 3 at any given time. And the absence of a clear agreement to delineate the rights is what causes those companies, if they don't go out of existence completely, they suffer pretty significant damage along the way. Number 5, raising capital. So here in the Wild West of Phoenix, we were joking before the program started, I moved here about 18 years ago, a little over 18 years ago, and did so for the opportunities that the ecosystem provided. I love working with entrepreneurs. That's my whole practice. And, it is a great place to do it. Recent survey came out just to demonstrate how great things are going in Phoenix, kind of global and North American ranking, if you saw that recently. So it is a great place to be an entrepreneur. The same entrepreneurial spirit, however, lends itself to folks not really paying attention on the legal side. The raising capital issue in particular is one of those places where people either don't know the rules or simply don't pay attention to them. And there's lots of things and lots of places where you can cut corners as an entrepreneur. The capital raising process is not one of them. The IRS is the other agency you don't want to tangle with. So cut corners in other areas. You may find yourself losing some dollars. Your company may go out of business. But when you mess around with the securities rules, you may find yourself committing a felony. And that's definitely not the place you want to be as a entrepreneur. So this is a program that we do quite frequently. I'll show you at the end of the program some other upcoming seminars that we have. You're welcome to attend. This one we do quite a bit, at least once every couple of months. And if you're thinking about raising capital at some point in the future, I highly encourage you to check that out. We'll just give you the quick Reader's Digest because it's a complex topic. But suffice it to say, when you're starting to think about doing it, you trigger federal and state securities rules, and you've got to figure out which legal path you have. Sometimes you have just one path available. Sometimes you have multiple paths available based on the things you see on the screen there. How much money are you raising? How many investors are you bringing in? What kind of solicitation are you going to use to get those investors in the door? But you've got to follow the rules. You've got to pick your path. And once you start having conversations or send that first email out or do an interview with a publication that then becomes public because they posted on in a newspaper, on a website, or in a blog post or whatever. Before any of that happens, you got to figure out which path you're taking, and you've got to follow the rules. Again, lots of people either don't know about the rules or just kind of flagrantly don't follow them. And so you hear a lot of people in Phoenix say, well, hey, no one in my space or my industry is doing this. This is the way they do it. So why do I need to do it differently? If you come to the program, we call those kind of those legal myths out there for capital raising, the everyone else does it myth. And that's not going to save you if things go sideways. The defense is not, well, all my friends and others I know in my space are doing it wrong. So me doing it wrong too is okay. It's not. We could tell you on this one as well, any number of horror stories. A quick one, we had a gentleman who attended the freestanding presentation on the issue, 10 years in the real estate space, flying below the radar. Nobody has really heard of him, never in the paper, et cetera, just doing his own thing, small time real estate kind of investment company. attended the program, indicated after that had been doing it wrong for 10 years, hadn't been following any of the rules, didn't know about them. And so said, hey, I'll come in and visit with you. Let's figure out how to get it right. So good news is I've not gotten any issues, no problems so far. So I want to stay out of trouble. He came in twice after the program, once by himself and the second time with some friends to find out what he needed to do, kind of get the homework that I would typically give out to the new clients and go off and hopefully do it. The third call he put in was not the charm, as he proceeded to say, hey, we've got to urgently meet. I've got my third notice, which was the first mistake. You never wait for your third notice, but he was on his third notice of criminal investigation from the Arizona Securities Commission. And the span of time between the seminar and this third notice was just a matter of months. And it was clear that someone at one point or another on one of his investments didn't like the outcome, decided to turn him in to the regulators. And while the SEC might not be interested in this kind of local small operator, the securities commissions at the state level are very interested. And with unlimited time and resources, they try to track down each and every complaint and figure out what's happening. He never showed up for that third meeting. Doesn't seem to be in Arizona anymore. I Google him once in a while, and it's unfortunate. He may have not done anything wrong. He may. We'll never know. But the fact is, it's kind of a life-changing situation when you get investigated for securities fraud. So again, anyone who's thinking about doing it, encourage you to attend the subsequent program, figure out how to navigate the process. It's not as bad as it sounds. It's not nearly as expensive as people think, and getting it right, really important to be able to sleep well. Number 6, failing to protect your IP. So everybody has IP. Folks think, hey, I'm not a company with a patented widget, so this doesn't apply to me. It applies to everybody. Everybody's got some IP. It may be the brand, your name, your trademark, and that's the core of your intellectual property. You may have trade secrets in the form of proprietary formulas for your product. Everybody has something. And doing kind of a subset of what we talked about in the free legal audit I referenced earlier is a good way to figure out what IP do you have or you may develop throughout the company's life cycle. A couple issues then surface. One, confirming that you actually own it. And another myth on the street is, which is understandable, people assume that if you pay, let's say, an outside independent contractor to develop stuff for you, and you pay that person or his company, you own the stuff. That seems pretty normal. I paid $50,000 to develop a website. They gave me the site. Of course, I own the rights to it. And unfortunately, the law does not default to that result. And so you've got to understand and implement appropriate documentation that would obtain ownership of the IP from anyone who's generating it, whether it's your co-owners, it's your employees, it's third-party consultants, et cetera. Everybody should sign something. And it's not a complicated document. It's fairly simple to make sure you own the stuff. Once you confirm you own it, then you figure out how you can protect it. There's both legal and non-legal ways to do it. One great way, obviously, is to file the patent, the trademark, et cetera, at the U.S. Patent and Trademark Office to give yourself nationwide protection. Strongly recommended. Confidentiality, non-compete, non-solicit type agreements here in Arizona, they are still enforceable. They've got to be appropriately drafted. But unlike our neighbor to the west in California, these are still enforceable for employees working for your company. And again, a lot of views that, hey, they're not worth the paper they're printed on, just not the case. Get it done right, and you can give yourself some critical protection from those who may leave the company at some point, either on a good or bad note, and go off and want to pirate your clients or set up shop down the street. So lots of lessons. Again, a quick one on this one. We had a company who's didn't have any proprietary widgets. They had trademarks that essentially were the trade names for their particular products. The products weren't particularly unusual. A lot of companies in the space, they went to sell the company, $30 million transaction. This was a bunch of years ago. The buyer found out through due diligence that they didn't own any of the trademarks because they hadn't gotten those trademarks assigned to the company. All these trademarks were developed by outside consultants. And so we spent the week between Christmas and New Year's chasing these consultants around the globe because people were on vacation in order to get their agreement to go ahead and formalize those assignments so we could close the deal. This is another one that ended well. They were still on good terms with the company, so they didn't attempt to extort the owner for what could have been, 6-7 figures worth of extortion, and assigned those over, and we got the deal closed. But you could easily see how that deal could have gone sideways, and it could have held up the process simply because that magic language wasn't in place. So think about how you're going to go ahead and protect your IP. Number 7, mismanaging key employee issues. We do a couple of different programs, standalone programs on these topics, so feel free to check those out. This statistic is kind of all over the map. I've seen it much higher, but the most recent one I saw was 50%. Clearly, it is a turbulent time, whether we call it kind of great resignation period here. We've got something, other term you use for it. Reality is things are kind of in flux. And so it's good and bad news. It's good if you want to kind of cherry pick some key employees from a competitor that they may be looking to make a move, and it may be a good opportunity for you. It may be also challenging for you to retain employees who you really think are key members of the team. There's a whole host of issues that are kind of assumed in this slide. We'll just throw them out quickly. There's few areas where you can get sideways and provide for potentially more liability than the employment space. There's just all sorts of rules, federal, state, that govern how you bring people onboard them, and then terminate them, saying things that might seem fairly innocuous to people you're laying off can invite a claim. And again, it's not always intuitive. You also need to figure out what employees want to stick with the company or to join your company. There's all sorts of different ways to do it. We do programs on how to talk about and motivate those employees kind of in the COVID era here. It's kind of been flipped on its head. 2+ years ago, people were talking about, hey, it'd be great to maybe get to work at home a day a week. That would be a big benefit, particularly the younger employees. And now the challenge is to try to get people back in the office, at least on a part-time basis. So different generations want different things. There's a great study that MetLife does each year. It's available for download free on the internet. Encourage you to check that out, no matter what business you're in. And this year it broke it out between three different generations and what they're looking for, which is often very different than what the employers think they're looking for. So things include employment agreements, different types of benefits, bonuses, opportunities to bring people in, either as actual ownership or through phantom ownership or liquidity bonuses. So lots of ways to incentivize the team. These issues we encounter daily, whether someone should be an employee or entrepreneurs much preferred independent contractor, avoids you having to pay the taxes, put them on the payroll. Just because you and the contractor agree in writing to say they're contractors doesn't make it so. There's a whole host of rules that make that determination for you. In California, it's almost impossible to have people being contractors if they're kind of in your space and would be otherwise treated as employees. Arizona's got a little more flexibility. Suffice to say, you've got to go through the analysis. Most companies get it wrong. The statistic is kind of off the charts. Most entrepreneurs get it wrong, at least in part. And the liability could be personal and go around that corporate shield if you get it wrong. So something to keep in mind. Second, when people get hired, they say, well, we're going to make them salaried. I don't want to pay them on an hourly basis. If I've got to hire them, that's a pain enough. Let's just put them on a salary. And again, there's rules that determine whether they can be salaried or they've got to be hourly. So I encourage you to work through those, make sure people are properly hired, properly certified as hourly or salary, and you comply with the applicable state rules. Probably very few issues more red hot than the discrimination harassment suits we see almost daily in the news. So you want to create a workplace that's got a zero tolerance policy, does some training. You've got protocols in place if some unfortunate incident happens. And so there's ways to lower the risk that's going to be the case. And if it does happen, mitigate the company's risk. You can't control what everybody does in the workplace, but you certainly can mitigate the problem should it arise and be able to deal with it quickly and efficiently. There's all sorts of things that we could talk about in the employment space. I think we're running a little bit low on time, so I'm going to skip the lesson learned on this one, apologize, and we'll jump into failing to use commercial contract best practices. So there is nothing more, I think, efficient and cost effective than creating your own forms. And hear lots of folks say, hey, I don't want to spend the time or energy to do that. I'll just take what the customers give me, or I will pull something off the internet. And internet's great at a lot of things. Using it for creation of legal forms is absolutely the worst way to go about it. And for folks who say, hey, what about those commercial services out there? We've got LegalZoom, we've got some others. My answer is pretty simple. I have never seen a document come out of LegalZoom that's been done correctly, ever. It's got a 100% failure rate, at least in things I've seen from clients, and we see them all the time. And the reality is it wouldn't cost any more to do it with us or another good firm than it would for you to pay for them to do it. So you're really not saving anything, and you really don't get a document or form or agreement that's going to be tailored to what you actually need. And so again, encourage you to go a different route when you are getting these documents in place. But creating your own forms with the different relationships you have is a huge cost and time savings. By having a customer agreement, for example, that captures the terms that you desire, you know what it says, you know what it doesn't say. You've put in place provisions that adhere to your risk profile. Some entrepreneurs want to take more risks than others. And it really creates a template for use kind of going forward. And you don't have to vet each and every customer agreement from the customer themselves. Each industry is a little different. Sometimes folks are required to use their customer forms. Just did a program with folks who contract a lot with the state or federal government. Obviously, in those circumstances, you may have to start with their form. But for everybody else, you have an opportunity to tee up whether it's an offline customer agreement, it's an online terms and conditions that the customer will click acceptance of as they go to buy your products or services. You have control of that process, and you really have the opportunity to, again, make sure that you put in place something that has the correct business terms, it has the correct limitations of liability, and it does what you're looking for. You want to process third contracts efficiently, so figure out what the internal process would be to do that. I think a big thing is having on the team good counsel, as well as other resources like your CPA and advisors and so forth. So you can turn to and put in a 5 or 10 minute call to ask some critical questions to, as opposed to winging it and finding out after the fact you've now got to fix it. With any of the things we've talked about, the cost to fix it versus to do it right on the front end is typically exponentially more. Just a recent example where someone didn't put in place a shareholders agreement, or at least didn't put in place a good one, I should say, for a partnership that they entered into a few years back. We just resolved after 2 years that particular dispute between partners. It costs more than 20 times what it would have cost in legal fees just to do it right on the front end, and 2 years of brain damage and stress associated with the whole negotiation process. So everything is always much cheaper and easier if you just get it done right on the front end. You've got to read the whole contract. And if you're not a big fan of legal documents, and most entrepreneurs aren't, you didn't go to law school, it's not something you're interested in, you should at least get yourself familiar with what is in the document, because it's an inevitable part of every company. No matter what industry, you're going to get hit with documents and the need to understand what you're signing up for. And most people take a look at the business deal kind of terms and then tune out, figuring that the reps and warranties and all the other stuff is kind of boilerplate. And tucked away in those terms are all sorts of issues that can come back to bite you. Things that seem like not a big deal. There's a lot of assumptions about how the law works and how contracts work. And you find yourself in a situation where, again, there's an issue under a contract, and per our lesson learned here, no damage limits. So we had a situation, again, this happens all the time, where we had a guy come in, he said, hey, I was pretty concerned last night. We got hit with a claim, but I reread my contract and I see a limitation of liability in section 7. And so I think we're okay, but I'd like you to take a peek. So I took a look and I said, well, I've got some bad news for you. But I asked him, hey, where did you get the form? It doesn't look like anything we've done. Where did you get this agreement from? Oh, I got it from my buddy. It should be in good shape. He took some time. He hired an attorney. They it's a good firm. He was comfortable with it, so I think it's okay. I said, I don't think so. I'm not seeing anything in here that would protect you. And so he got kind of concerned, and I said, hey, well, tell me this. What position was the buddy in when they had this contract prepared? He said, well, they were, I guess they were on the customer side. So this was something they were getting put in place from that perspective. That solved the problem, or at least the issue I had, pretty quickly. It was clear that the guy was on the other side of the deal when he had this form prepared, and it did protect the customer. Unfortunately, my client was on the other side. He was the service provider providing the services to his customers. And so on his side, there was no limitation liability, as you might imagine. It protected the customer really well. And so his customer wasn't going to have any issues. But unfortunately, there was no limitation liability in the contract for him as the service provider. So he'd been using a form that did the opposite of what he wanted. And now he was facing a potentially company ending claim. This one ended up getting resolved, but it could have been literally the end of the company. As with any small company, it doesn't take a huge claim to kind of put you out of business pretty quickly. And that was the issue he faced. So at the end of the day, you want to have something in place, again, that's going to give you the benefit of the business bargain that you're cutting, protect your company from liabilities that you probably didn't know existed, and make sure that you know each and every relationship, what's the worst case? If it goes sideways, what am I on the hook for? And in that way, you can quantify and be comfortable with the risk you're taking once you know what those risks are. So I encourage you to put together, if you haven't already, your forms. That's a big part of what we do in these legal audits I've mentioned a couple of times, is to take a look at what people have in place currently and help you identify areas where you may need to beef things up a bit or add some things that can protect you, some customary terms. Number 9, asking for an unnecessary fight. So we've got a lot of folks on the line. I suspect at least a few of you have been involved in a claim. Maybe it's gotten to litigation or arbitration, and encourage you to identify what causes problems to emerge. And we don't have time to go through everything on the screen there, but these are all things we see daily. We've got lots of litigators in the building, and they stay busy because people tend to fight. And any one of these, or a combination of these, can lead to an issue with you and the folks you're involved with. Again, whether it's an internal employee, or it's a customer, or it's a vendor, it's someone else in the relationship. We saw pretty clearly during the pandemic that if you're partnered up with unethical partners, whether again internally or externally, that's going to be a recipe for disaster when things go sideways. The pandemic caused us to go sideways in unprecedented ways, and pretty quickly it became clear that those who were partnered up with ethical folks were much better off. That partner was willing to kind of work with them, maybe make some sacrifices to keep that relationship going. Those who weren't saw a very different outcome, fighting, litigation, sometimes company ending events. And so the more you're in business, the more likely it is that you're going to get hit with some of these issues, and you want to understand why they pop up, and then find out and think through strategies to reduce the exposure. And again, for time's sake, we won't go through all these, but just a couple to note. We talked about the doing business with ethical people approach. Take informed business risks. Again, not knowing what's in the contract you're about to sign is not taking an informed risk. At least get it reviewed, have a once over with your friendly neighborhood attorney to understand what you're biting off. And again, it's your call as to how much risk you want to take on, but at least know what's in there. Build an escape hatch in the business relationship so that you can get out if things don't work out. That's important. People assume that you can just terminate any contract at will if there's a problem, and that's not how things work. Make sure you get a reality check if a dispute does arise. This happens all the time. We get paid in part to do that when there's a dispute that pops up and folks say, hey, I think I've been wronged. What are my rights? What can I do? And we always encourage folks to kind of get that outside reality check, because what you think may be kind of your rights and obligations and so forth may not be the case. And so You want to make sure that you get a look at the appropriate facts, circumstances, documents, etc., and understand what what leg you have to stand on before you go out and start World War III with a customer, for example, when you think things have gone in ways they shouldn't. Suffice to say, don't send any kind of communications, emails, don't do calls, don't do texts, don't send things through social media. You've probably heard it 1,000 times, but people continue to do it. Our litigators can give you a trillion examples of crazy messages that went out that impacted the outcome of cases because it just destroyed the credibility of the client or the other side. And so really sleep on it and just don't do it. It's going to be preserved forever, and it's going to come back to bite you on the back end. Lesson learned here, I know we're running a little short on time, is that people don't behave in ways that make any sense. Oftentimes, there's people who will spend, $150,000 to fight over a $50,000 issue, and we see this happen on a daily basis. People don't, engage in negotiations. Sometimes don't engage in dispute resolution in a logical fashion. And if you're up against one of those folks, it's gotten personal. You may see yourself involved in a dispute or lawsuit that is going to be extremely expensive, extremely stressful, a lot of brain damage involved, and without a clear outcome. And so if you see that type of thing emerging and the person on the other side not behaving rationally, you really want to strategize and figure out a way to resolve those issues before it gets escalated to the point where people are fighting it out in a court setting. Because if not, again, you may be in for a very expensive and very destructive battle. And it doesn't always resolve itself by just offering a kind of a rational economic settlement. Finally, planning for a liquidity event. So everybody in the call who's launched into a business or about to launch into a business has sacrificed a ton to start and grow your company. And the longer you've been in business, the more sacrifices made financially, free time, time away from family, et cetera, to build your company. That's the nature of the entrepreneurial lifestyle. And what we see and what is most most tragic is people don't plan to exit the business. They get in, a lot of stuff to do to get the company off the ground, start to generate those customers, and really don't think through, how am I going to exit the business and what does that exit look like? And so encourage you to get the company in good shape, certainly from a legal standpoint, but from other perspectives as well, and kind of run it every day like the sale is coming tomorrow. And that's going to increase and maintain the value of the company, because if the pandemic taught us anything over the last 2 years, is you don't know what's coming. And you may have thought there's a sale event coming in 10 years and it comes tomorrow, and you're forced to take action, maybe a change in lifestyle or a health issue. Maybe the economy requires a quicker sale than you anticipated. Maybe the industry is changing. Maybe there's some regulatory things coming down the pike. Suffice to say, you don't know when that day is going to come. You have a plan A, but you also have a contingency plan. And if you run the business as though you're going to have to sell it tomorrow, just like thinking you have to maybe sell your house tomorrow, you're going to keep things in better order and make sure that you've quantified those issues and resolved them in advance. The other thing you want to think about doing, and we'll wrap things up here, is understanding what the company will be worth at sale time. Few people go through and understand that there's a customary approach to selling businesses. It's typically a multiple of profits. The question is, how is your business going to be valued? It's not a one size fits all multiple. Some businesses get sold for 1 times profits. That's 1 times an annual profit number. Other businesses, it may be 10 or 15 times. Some businesses get sold for other than a profit multiple, but point being, there's not a standard formula that you can implement. And so what we see and kind of what's most tragic, people who have built businesses for 10, 20, 30 years, assuming a multiple that is not accurate for their particular industry and for their particular size of company. And so they go to sell thinking, hey, I'm ready to retire and do other stuff, only to find out that the proceeds they're going to get are a fraction of what they estimated they'd be, because again, they just never researched what that sale might look like. And they find themselves paying off some debt and going right back to work. That is a very difficult thing to to wake up to, and you want to make sure. And there's lots of resources, free resources, and others to get an understanding today before you start the business, ideally, but certainly if you're already in business, to be able to quantify what that exit event might look like, and that gives you a much better roadmap to understand what you need to grow the company to in order to get the exit that you're anticipating that's going to be necessary for retirement or whatever else you've got on your agenda. So do some homework, figure out what that looks like, and bake that into your business plan on the front end. Or again, if you're already in business, get some kind of reality check as to where you're headed. So with that, we're going to wrap up here. Let me just tell you a final tip, and that is to get a legal checkup on a fairly regular basis. Things change very quickly. Colorado, for example, is about to put in place a much harsher restriction on non-competes. That's, again, not happening currently in Arizona at least, but that's just one example. We had a client who was going to do some non-compete stuff in Colorado, and this new rule is kicking in within, I think it's the next 60 plus days or so, and is going to kind of change the landscape there, at least on that particular issue. So things crop up. To the extent you create forms today or put in place programs today, at least every year, maybe 6 months, kind of circle back and say, hey, what's changed? How do we need to update things? Worst case is to be able to sleep at night, or think you can sleep at night with, let's say, a employment agreement or employee restrictive covenant agreement in place. That employee decides to leave and start taking clients with them. You think you've got an enforceable agreement, only to find out that form that was drafted 5-6 years ago is now out of date and may not be enforceable in the way that you contemplated. And so you've put your client base at risk because you didn't update the documents. So just encourage you to kind of keep that in mind. So with that, I'll just pop up on the screen real quick, and we will wrap things up with some other upcoming programs. So to the extent that you are up for any of these topics, feel free to join us at any of these programs. I will show you in a second. There's a link that I keep, a little personal website that has access to the programs, registration links, et cetera. They're for a variety of different organizations. We've got a couple live ones. Most of them are still virtual. So feel free to check any of those out. Also invite you to check out our Emerging Business Seminar program. Some of you may have been to that. We do it live each and every month, except for July. We do take July off, just like Robert's doing for his program. And we'll be back in August, starting our 14th year. And again, all the upcoming seminars are listed at that website you see at the bottom of the screen. So feel free to jot that down and check that out. We'd love to see you at the programs. They're all free, and they're all geared toward entrepreneurs just like this one. So I know we packed a lot in. I think we're out of time, so I'm going to wrap it up. And again, if you'd like to follow up to chat about anything discussed in today's program and or to maybe inquire about that legal audit, we would be happy to chat with you. So feel free to shoot me an email or give me a call, and we'd love to talk with you.
Excellent. Thank you, Brian. That was a fabulous presentation. A lot of information packed into a short period. So we want to thank all those that attended today. We did have one question we didn't quite get to, but hopefully you can reach out and contact Brian. He can answer that for you. Again, on some of those events that Brian listed, some are with SCORE, and the other ones that said WBC is the Women's Business Center. So if you Google Women's Business Center Phoenix, it'll pull up their information as well. So thank you, Brian, for sharing those other workshops. And again, thank you for the presentation today. With that, we are right at 10 o'clock. We will go ahead and wrap up. We hope to see everybody next Tuesday morning, 7 a.m. Until then, have a great week, and we'll see you soon. Thank you.
Thanks again. Take care.
Thanks, Brian.